1, 2. Okay. I can't actually remember where we're up to. Did we read 198? Okay, we haven't watched what read 198 yet, so that's where I start. All right. Bring that up. Um, nice, by the way. Um, part 4. XP? Interesting. All right. 1, 2, 3, 4. Shall we get into it then? 198. Welcome to part of uh, reading legislation again, I guess. All right, all right, all right, all right. It's naughty. The audio sounds okay. 198. Delegation of functions, duties, or powers of chief executives. I'm in the shot, am I? I hope so. 1. While he or she has the territorial authority, general authority to do so, a chief executive may delegate to any person. Is this slide? Yes. All right. Either generally or particularly any of the chief executive's functions, powers, and duties under this act. Oh, I could totally do this. Oh, it's so hard to see, actually. Whereas after 2, the chief executive must not delegate a general power of delegation. Got headphones on, sunnies on, and a hat on over the headphones. A person to whom a chief executive delegates a function, power, or duty under subsection 1 may delegate the function, power, or duty only with the prior written consent of the chief executive. A delegation must be in writing and may be able to. I could. Oh yeah, it's polarized. May be able to. May be made to subject to any restrictions and conditions that the chief executive thinks fit, and must state each function, power, or duty being delegated and is revocable at any time in writing, and does not prevent the performance of a function or duty or exercise of any power by the chief executive. No. Yeah. Copies of all delegations must be kept in the office of the territorial authority and be available for inspection during ordinary business hours. Wow. A person to whom any functions, duties, or powers are delegated may perform those functions and duties and exercise those powers in the same manner and with the same effect as if they had been conferred directly by this act and not by delegation. Until a delegation is revoked, it continues in force and according to its tenor. A person who appears to act under a delegation is presumed to be acting in accordance with its terms in the absence of evidence to the contrary. Okay. Let's have a look at where our 198 is. Like almost halfway through. Because the end is 400. At 198. Go to 199. Annual report. Within 3 months after the end of every financial year, every territorial authority must prepare and send to the licensing authority a report of the proceedings and operations of its licensing committees during the year. The licensing authority may specify the form of the annual report and the matters to be included in the report. The licensing authority or licensing committee must, on payment of any reasonable fee, may prescribe, provide a copy of each report to any person who asks for one. Every annual report required to be prepared under this section is a public record for the purposes of this act. Nice. Nice. A copy of every annual report must be made available by the Territorial Authority for inspection free of charge and made available on the internet site maintained by or on behalf of the Territorial Authority for a period of not less than 5 years. Boom. 200. Yeah. Finally, I think 200, if it was 418 was the end, 209 will be the halfway, so nearly halfway. 200. Application of Local Government Official Information and Meetings Act 1987. Every licensing committee is a committee of its territorial authority. The provisions of the Local Government Official Information and Meetings Act 1987, other than Part 7, apply to every licensing committee. Subsection 2 overrides Subsection 1. Cool. (201) General provisions relating to licensing authority and licensing committee. Licensing authority and licensing committees have powers of commissions of inquiry. Within the scope of its jurisdiction, the licensing authority and every licensing committee must be treated as being a commission of inquiry under the Commissions of Inquiry Act, and that Act with any necessary modifications applies accordingly. Subsection 1 is subject to this Act. The power of the licensing authority or a licensing committee under the Commissions of Inquiry Act 1908 to issue summonses requiring the attendance of witnesses before or the production of documents, or to any other act preliminary to or incidental to the hearing of any matter by the authority or committee, may be exercised by the chairperson or by the secretary purporting to act by direction or with the authority of the chairperson. Wow. This is getting annoying, these. Yeah. In addition to its powers under the Commissions of Inquiry Act 1908, the licensing authority or licensing committee has power at any time, if it thinks fit, to rehear any matter that it has determined. (202) Procedure. If no objection to an application is filed within the prescribed time, the licensing authority or licensing committee concerned may either grant the application on the papers or convene a public hearing to consider the application. With the leave of the chairperson of the licensing authority, a licensing committee may refer the matter to the licensing authority for decision. Okay. Where an objection is filed within the prescribed time, the licensing authority with the licensing authority or licensing committee concerned must convene a public hearing to consider the application, unless the application is withdrawn or having considered the application, the authority or committee believes that the objection is vexatious or based on grounds outside the scope of this act, or the objector does not require a public hearing. The licensing authority or licensing committee concerned must give at least 10 working days of notice of the public 10 working days notice of the public hearing to the applicant and each objector and the constable, inspector, and the medical officer of health, to whom a copy of the application must be sent in accordance with this act. Ooh. The hearing of a matter or any part of it by the licensing authority or licensing committee concerned may be conducted by telephone, audiovisual link, or other remote access facility if the licensing authority or licensing committee considers it appropriate and the necessary facilities are available. Where we're up to. 6. The licensing authority or licensing committee concerned must consider any reasonable request made by a person to participate in the hearing of a matter or any part of it by telephone, audiovisual link, or other remote access facility. Okay. Next. 203. Proceedings of a licensing authority and licensing committees. Whenever the licensing authority meets for the purpose of hearing any appeal, or the authority or any licensing committee meets for the purposes of exercising or performing any power or function that is required by this act to exercise or perform a public hearing, the meeting the meeting must, except in the case to which Section 2021 applies, and subject to the provisions of subsections 3 and 4, be held in public. Any other meeting of the authority or of any licensing committee may, in the discretion of the authority or committee, be held in public or in private. Whenever the authority or committee holds a public hearing, it may, in its discretion, hold any part of the sitting in private if, having regard to the interests of persons appearing and being heard and to the public interest, it thinks proper to do so. Okay. The authority or committee may, in any case, deliberate in private as to its decision on any matter or as to any question arising in the course of any proceedings. The authority or committee may make an order prohibiting the publication of any report or description of any part of the proceedings in any matter before it, but no such order may be made prohibiting the publication of the names and descriptions of the parties to the matter or of particulars of any premises affected. In considering whether to make an order or prohibiting publication, the authority or committee must consider both the public interest and in being able to learn of the proceedings of the authority and licensing committees and the privacy of persons whose affairs are before the authority or committee. In any proceedings before the authority, any counsel or solicitor engaged by the authority pursuant to this act may appear and be heard as counsel assisting the authority. Any decision, order, direction certificate or other document issued by the authority or committee may be signed on its behalf by the chairperson or the secretary. Subject to the provisions of this Act and any regulations made under this Act, the authority or committee may regulate its procedure in such manner as it thinks fit. Then I'll click 203A. Licensing committees must establish appropriate procedures. A licensing committee must establish appropriate procedures to consider applications. When doing so, a licensing committee must ensure that those procedures avoid unnecessary formality, including, for example, without limitation, by making appropriate provision about the location and timing of the hearing, the layout of the venue of the hearing, the timetable of the hearing, and the language and terminology to be used at the hearing, and do not permit parties or their representatives to question other parties or witnesses of other parties, and do not permit cross-examination, and allow for tikanga Māori to be incorporated into proceedings, and allow for persons to be heard, and make submissions in te reo Māori. To avoid doubt, nothing in subsection 1 applies to the licensing authority. Oh, that's a long one. Right of certain persons to appear in proceedings. This section applies to the following proceedings: an application for a license under Section 99, an application for a variation of the conditions of a license under Section 120, an application for the renewal of a license under Section 127, an application for a temporary authority under Section 136, an application for a special license under Section 137, an appeal against a decision of a licensing committee to the licensing authority under Section 154. With the leave of the chairperson of the licensing committee or the licensing authority, as the case may be, any of the following persons may appear and be heard, whether personally or by counsel, in any proceedings stated in subsection 1. An employee, volunteer, or contractor of Fire and Emergency New Zealand authorised to undertake fire safety inspections. A person authorised in that behalf by any territorial authority. Any person who satisfies the licensing committee or the licensing authority that he or she has an interest in the proceedings, apart from any interest in common with the public. To that, I say, nice. Nice. We're up to 3. In the case of proceedings specified in subsection 1 that are before a licensing committee, any of the following persons may appear and be heard, whether personally or by counsel, and call and examine their own witnesses: the applicant, an objector, an inspector, a constable, and a MOH. That's easy to say. In the case of proceedings specified in subsection 1 that are before the licensing authority, any of the following persons may appear and be heard, whether personally or by counsel. In court, am I reading the exact same thing? And cross-examine instead of thing, and the exact same list below. Any witnesses. 205. Right of persons to appear in relation to appeal under Section 81. The following persons may appear and be heard, whether personally or by counsel, and call, examine, and cross-examine witnesses in an appeal under Section 81, which relates to an appeal to the licensing authority against any element of a local alcohol policy that is a matter relating to licensing. The appellant, any person authorized in that behalf by a territorial authority. With the leave of the chairperson of the licensing authority, the following persons may appear and be heard, whether personally or by counsel, and call evidence: an inspector, any constable, any MOH, any other party who made a submission as part of the special consultative procedure on the draft local alcohol policy, and any other person who satisfies the licensing authority that he or she has an interest in the proceedings apart from any interest in common with the public. 206. Rights of persons to appear in relation to certain applications for variation, suspension, and cancellation. This section applies to the following proceedings: an application for the variation, suspension, or cancellation of a license under Section 280. An application for the suspension or cancellation of a license in respect of certain offences under 281. An application for the variation, suspension, or cancellation of special licenses under Section 283. An application for the suspension or cancellation of a manager's certificate under Section 285. An application for the suspension of a license or for non-compliance with public health or fire precaution requirements under Section 286. The following persons may appear and be heard, whether personally or by counsel, and call, examine, and cross-examine witnesses: the applicant and the respondent. With the leave of the chairperson of the licensing committee. Cool. Correct. Thanks, Amelia. Yeah, it's cool. With the leave of the chairperson of the licensing committee or the licensing authority, as the case may be, the following persons may appear and be heard, whether personally or by counsel, call evidence: any inspector, any constable, any MOH. 207. The evidence in proceedings before licensing authority or licensing committee. The licensing authority or licensing committee concerned may receive as evidence any statement, document, or information or matter that is, in its opinion, may assist to deal effectually with any matter before it, whether or not the statement, document, or matter would be admissible in a court of law. Nice. That's the end of the nice. Subject to subsection 1 and to section 203A, 2B and C. The Evidence Act 2006 applies to the authority or the committee and to the members of the authority or committee and to all proceedings before the authority or committee. I've said authority or committee so many times. In the same manner as if the authority or committee were a court within the meaning of that act. 208. A nice short one. Licensing authority or licensing committee may waive certain omissions. Where any person has neglected or omitted to any act or thing in the precise manner or within the precise time prescribed by this act, the licensing authority, or as the case may require, the licensing committee or the chairperson, if satisfied that the neglect or omission was not willful, may waive the same on such terms as they think equitable. Me win the authority or committee. 100, 100, 100. Yeah, the authority or committee. 209. Licensing committee may state case for opinion of licensing authority. A licensing committee may state a case for the opinion of the licensing authority on any question of law arising in any proceedings before it. The licensing authority may order the removal into the High Court of any case stated under this section, and on removal, the High Court has the same power to adjudicate on the proceedings as the licensing authority had. The provisions of Subpart 8 of Part 6 of the Criminal Procedure Act 2011, so far as they are applicable and with the necessary modifications, apply to any case stated under this section. Fun fact, that's Section 209. This has 418 sections. That is technically, depending on the size of the section, there's A's and stuff in there as well, that is halfway through the entire document. Halfway. Now to do the other half, as we come into the other half with 210. Another short one. Nice. Licensing authority may state case for opinion of High Court. The licensing authority may state a case for the opinion of the High Court on any question of law arising in any proceedings before it. The provisions of Subpart 8 of Part 6 of the Criminal Procedure Act 2011, so far as they are applicable, and with the necessary modifications, apply to any case stated under this section. 211. Decisions to be given in writing. The licensing authority and every licensing committee must give its decision on an application in writing and must state in it the reason for the decision and what reports on the application were received and the attitude towards the application of every report. The statement of the attitude towards an application of any report may be in general terms only. The licensing authority or licensing committee must give a copy of the decision to the applicant and each objector who appeared at the hearing and any other objector who requests a copy and each person referred to in Section 2024C. The licensing authority must take all reasonably practicable steps to ensure that that copies of its decisions are publicly available. Every territorial authority must take all reasonably practicable steps to ensure that the copies of its decisions of its licensing committees are publicly available. A decision takes effect on the date stated in the decision, or if no date is stated, on the date the decision is given. Eliminate. Contempt of licensing authority. A person commits an offence if the person willfully insults or obstructs the licensing authority or any member of it, a witness or an officer of the licensing authority during a sitting of the licensing authority or while a member hang on a minute. While a member a witness or an officer is going to or returning from a sitting of the licensing authority or willfully insults or obstructs any person in attendance at a sitting of the licensing authority or willfully interrupts or otherwise misbehaves at a sitting of the licensing authority or willfully and without lawful excuse disobeys any order or direction of the licensing authority in the course of the hearing of any proceedings. Those are offences. Ah. A person who commits an offence against subsection 1 is liable on conviction to a fine not exceeding $1,000. The licensing authority may order the exclusion from a sitting of the licensing authority of any person whose behaviour, in the opinion of the licensing authority, constitutes an offence against subsection 1, whether or not the person is charged with the offence, and any officer of the licensing authority or constable may take any steps that are reasonably necessary to enforce the exclusion. 212. Subpart 7. Management of licensed premises. An appointment of managers on licenses, off licenses, and club licenses. Every holder of an on license other than an on license endorsed under Section 37, an off license, or a club license must appoint a manager or managers in accordance with this part. 213. Appointment of manager, special licenses. Every holder of a special license must appoint. Every holder of a special license must appoint at least one manager in accordance with this part. The licensing committee may exempt the holder of any special license from the requirements of the subsection 1 if it is satisfied that the license or some other person nominated by the license will manage the conduct of the sale of alcohol pursuant to the license. 8 degrees, jeez. One moment. Alright, that was warmer. Where was I up to? Manager to be on duty at all times and responsible for compliance. Except as provided in Section 215, a manager must be on duty at all times when alcohol is being sold or supplied to the public on any licensed premises. Okay. A manager on duty on any licensed premises is responsible for the compliance with and enforcement of and provisions of this Act, and the conditions of the license in force for the premises, and the conduct of the premises with the aim of contributing to the reduction of alcohol-related harm. At all times, while a manager is on duty on any licensed premises, the full name of the manager must be prominently displayed inside the premises so as to be easily read by people using the premises, and the person named as manager at any time is to be treated for the purposes of this Act as the manager at that time. At all times when alcohol is being sold or supplied on licensed premises, the licensee must take all reasonable steps to enable the manager to comply with this section. The manager. 215. Circumstances where Section 214 does not apply, which is that. When does that not apply? We shall find out. The requirement to have a manager on duty at all times when alcohol is being sold or supplied to the public on any licensed premises does not apply to premises for which a club license is held, or premises for which an on license endorsed under Section 37 is held, or premises for which an off-license endorsed under Section 40 is held, or premises for which an off-license but no on-license is held, where fruit or vegetable, wine or grape wine is made, or premises for which an off-license but no on-license is held that are situated on land from which there is harvested produce from which fruit or vegetable wine or grape wine is made. At any time, the requirement to have a manager on duty at all times when alcohol is being sold or supplied to the public on any licensed premises does not apply to any premises for which both an off-license and an off-license are held if the premises are the premises where fruit or vegetable wine or grape wine is made, or premises situated on land from which there is harvested produce from which fruit or vegetable wine or grape wine is made. At that time, no alcohol is being sold or supplied to the public for consumption on the premises. That's the other option. A manager in respect of those premises is only required to be on duty if it is a condition of the license or a condition of the endorsement of the license, and only for the days and times that it may be specified. If it is a condition of the license or the endorsement of the license that a manager be on duty at any particular time, Section 214(2)(4) applies to a manager of the premises when he or she is on duty. 2.6. Manager certificates. Managers to hold certificate. A person may not be appointed as a manager of any licensed premises for the purposes of this Act unless the person is over the age of 20 and holds a manager's certificate granted under this part. Subsection 1 does not affect any manager's certificate granted before the commencement of this section to a person under the age of 20. Manager's certificate. A manager's certificate authorizes the holder to manage any licensed premises. A manager must hold prescribed qualification. The licensing authority or a licensing committee must not issue or renew a manager's certificate on or after the commencement of this section unless the manager holds a prescribed qualification. In this section, prescribed qualification means a qualification prescribed by regulations made under this Act, or the successful completion of a course of training, the requirements or criteria of which have been prescribed by the regulations made under this Act. 219. Applications for manager's certificates. Every application for a manager's certificate must be made in the name of the person who will hold the manager's certificate if the application is granted, and be made in the prescribed form and manner, and contain the prescribed particulars, and be accompanied by the prescribed fee. An application must be filed with the following licensing committee, where the applicant intends to be the manager of any particular licensed premises, the licensing committee with which the application for the license was filed, or in any other case, the licensing committee for the district in which the applicant is residing. Reports. On receiving an application for a manager's certificate, the secretary to the licensing committee concerned must send a copy of it and of each document filed with it to the constable in charge of the police station nearest to the premises where the applicant intends to be the manager of any particular premises, or the secretary's office where the applicant intends to be the manager of any particular conveyance, or the applicant's place of residence in any other case, and an inspector. The inspector must inquire into and file with the licensing committee a report on the application. The police must inquire into it, and if they have any matters in opposition, file a report on the application within 15 working days after receiving the application. The licensing committee may assume that if no report is received from the police within 20 working days after the application is referred to the police, they have no matters in opposition to the application. The secretary must send to the applicant a copy of any reports filed with the licensing committees under this section. Who decides an application for a manager's certificate? A licensing committee may decide any application for a manager's certificate. With the leave of the chairperson of the licensing authority, a licensing committee may refer an application for a manager's certificate to the authority for a decision. The licensing committee must give the licensing authority the complete file relating to any application to be decided by the licensing authority. In the section, complete file means the application and any papers filed in support of it and any reports made under section 220. 222. Criteria for manager's certificates. In considering an application for a manager's certificate, the licensing committee or licensing authority, as the case may be, must consider the following matters: the applicant's suitability to be a manager, any convictions recorded against the applicant, any experience, in particular recent experience that the applicant has had in controlling any premises for which a license was in force, any relevant training, in particular recent training, that the applicant has undertaken, and evidence that the applicant holds the prescribed qualification under section 218. Any matters dealt with any report made under section 220. 223. Duration of manager certificates. In this section, end of its currency for a manager's certificate that has been renewed before means the close of the last day of the period for which it was last renewed. For a manager's certificate that has not been renewed before, it means the close of the day 12 months after the day it was issued. Let's go! That's right. Oh, you're in the Discord call as well. Hello. Let's go. 48 minutes. Yeah. Right. Oh, because you've only sent one chat and it really has. Oh, now you're number one. You've now sent two chats. Wow. All right. I'll keep reading. How do you? Oh, you've both got 50 XP. Yeah, yeah. What was it up to? Okay. I think it was up to end of the prospective renewal period. Yeah. For a manager for a manager's certificate that has been renewed before means the close of the day 3 years after the last day of the period for which it was last renewed. For a manager's Sorry. For a manager's certificate that has not been renewed before, it means the close of the day 4 years after the day of it was issued. If no application to renew a manager's certificate has been made before the end of its currency, it expires at the end of its currency. Wow, who would have known? The crickets. Um, a, a manager certificate expires as provided in subsection 4 or 5, or continues in force as provided in subsection 6 if an application to renew it has been made before the end of its currency, but it has not been renewed before the end of its currency. If a decision to re- refuse to renew the certificate that has been made before the end of the prospective period, there's no one at my door. Before the end of the prospective period renewal period, it expires. You got me. You got me. Because the door's on that side. That's the window. If a decision if a decision to refuse the if a decision to renew refuse to renew the certificate has been made before the end of the prospective new renewal period, it expires on the day stated under section 2283. If no decision on the application to renew the certificate has been made before the end of the prospective renewal period, it expires at the end of the prospective renewal period. If a decision to renew the certificate is made before the end of the prospective renewal period, its renewal takes effect for the period stated under section 2282 at the end of its currency. This section is subject to the provisions of this Act relating to the suspension, cancellation, and surrender of manager certificates. Manager certificates. Yeah. 2 to 4. Application for a renewal of a manager certificate. The holder of a manager's certificate may apply in accordance, not accordion, with its with this section for renewal of the certificate. Every application for the renewal of a manager's certificate must be filed with the licensing committee for the district in which the applicant is presently employed as a manager, or if the applicant is no longer employed as a manager, the licensing committee for the district in which the applicant is residing, and be made before the date of the expiry of the certificate, and be made in the prescribed form and manner, and contain the prescribed particulars, and be accompanied by the prescribed fee. Wow. Yeah. I gotta go to the toilet. I'll be back in a couple seconds. How do I do this? Deactivate. Oh, his emote spamming. Alright. Oh! This hat. He's got the emote spam. That doesn't fit up on the top of my head, but sure. It's just like this hat's just perched on the top now. Actually, do you want to read a section out? All right, hang on. I'll turn my Discord audio on. Hang on. I just got to sort out audio. Can I get audio input capture? And properties. Headset. 1, 2. Hang on, I gotta go to this one now. Hang on, I'll listen to the stream now. Ready? Say something again. Oh, it's not coming through. Properties, can I... Okay, let's delete that one. Oh, that was my window. Add. Oh, it's audio output capture. Whoops. Oh, it's not coming through. Now? Can I... Okay, let's delete that one. Now speak, GJ. Oh, that was my window. Add. Oh, it's audio output capture.
Oh, there it is. I can hear my voice. Yeah, it works. It works. Right, where am I reading from?
Now? Can I... Okay, let's delete that one. Now
where am I starting from?
Oh, that was my window. Add. Oh, it's audio output capture.
Oh, there it is. All right.
Oh, it's looping now. Okay.
Is this gonna get picked up?
Hang on. I'm gonna open up my phone to just test. Now say something.
Yeah.
Yeah. We on. All right. Read section 225, eh? If you want.
Okay. Yeah, this on me. Reports and applications for renewals.
Yeah.
On receiving an application for the renewal of a manager's certificate, the secretary of the licensing committee concerned must send a copy and each document filed with it to the constable in charge of the police station nearest to 1. The premises where the applicant is the manager of any particular premises, or 2. The secretary's office where the applicant is the manager of any particular conveyance, or 3. The applicant's place of residence in any other case, and B. An inspector. 2. Where the hell is your stream gone?
What happened there? Hang on.
How am I supposed to read this?
What happened? Is it back?
Not yet.
Give it a couple of seconds. Yeah, do you see it now?
Oh, let's go. Okay. B2. The inspector must inquire into and file with the licensing committee a report on the application. The police must inquire into, and if they have any matters in opposition, file a report on the application within 15 working days after receiving the application. 4. The licensing committee may assume that if no report is received from the police within 20 working days after the application is referred to the police, they have no matters in opposition to the application. 5. The secretary must send to the applicant a copy of any reports filed with the licensing committee under this section.
Whoa!
Let's go.
Nice.
Let's go.
Oh, that's so cool. Oh, you emote spam the chat.
No, don't worry. I can do the next one too.
Oh, you want to? You want to?
Yeah,
I learned so
hold on.
much. I learned so much from listening to you read that.
Yeah.
We're up to section 226.
So good. All right.
Who
Hold on,
decides
just
an
give me
application
one.
for renewal of manager certificates?
Oh, okay. Hold on, let me just hit this one. All right, let's go.
This is quite funny.
Who decides applications for renewal of manager's certificates? 1. A licensing committee may decide any application for renewal of a manager's certificate. 2. With the leave of a chairperson of the licensing authority, a licensing committee may refer an application for a renewal of a manager's certificate to the authority for decision. The licensing committee must give the licensing authority the complete file relating to any application for renewal to be decided by the licensing authority. In this section, complete file means A. The application and any papers in support of it, and B. Any reports made under section 225. Let's go.
Let's go.
Right, that was my reading of the day.
Oh yeah. Hang on. We gotta. What was that?
Valid.
Yeah. Okay, that was insane. I wasn't expecting the voice changer on that.
Oh. That's the banana. Now I gotta fix my settings again.
Shall I read the next one?
Yeah.
Criteria for renewal. I don't have a voice changer, so I can't do that.
Oh, nice.
Ah. We got a couple viewers. I wonder what people are missing out.
Is one of them you?
One of them's me because I've got the chat open on my phone.
Yeah.
Because
I saw Corey coming before. I tried to get Corey in.
Oh yeah, get Corey.
He came in and then he left.
Oh, yeah. It's because on this screen, on my actual studio screen, it says something went wrong, and where the chat is supposed to be, it doesn't work. Like there's usually a chat thing that will pop up on the screen here, but it just doesn't work, so I have to have it on my phone instead.
I see.
But yeah. Shall I keep reading?
All right.
Criteria for renewal. In considering an application for the renewal of a manager certificate, the licensing authority or relicensing committee concerned must have regard to the following matters: the applicant's suitability to be a manager, any convictions recorded against the applicant since the certificate was issued or last renewed, the manager in which the managers has managed the sale and supply of alcohol pursuant to the license with the aim of contributing to the reduction of alcohol-related harm. any matters dealt with in any report made under Section 225. 228. Decision on application for renewal. Should I mute the Discord now just in case Corey comes in and says something? Do you reckon?
Yeah, 100%.
Yeah. Just
I agree.
Corey's online, so.
Probably doing their uni work.
Oh, you said no. Nope.
Nope.
Wait, we have
Nope.
we have 2 concurrent viewers. So, are you also the other viewer?
Yeah, I had to read the thing.
True.
On the stream.
I'll turn this audio capture off.
Yeah.
So I think it'll just be my microphone now. Just in case Corey comes in. Studio. Was Corey playing 5? Oh, he's not playing a game right now. Oh, guess what? Decision on application for renewal. After considering an application for the renewal of a manager's certificate, the licensing authority or licensing committee or other way around, but sure, must either renew the certificate or refuse to renew it. If it renews the certificate, the licensing committee or licensing authority must specify a date, being no later than 3 years after the date on which the renewal takes effect. What's been something effect on which the certificate expires unless it is again renewed under this section. Did that stay on? It doesn't like me highlighting, apparently. Okay, maybe not. If the committee refuses to renew the certificate, it must state the day on which the certificate expires and must be no later than 3 months after the date of its decision. Okay, that is good to know. Alright. 229. Miscellaneous provisions. Whoa. Temporary manager. In any case where a manager and boom and boom. In any case where a manager is ill or absent for any reason, or is dismissed or resigns, the licensee may appoint as a temporary manager a person who is not then the holder of a manager's certificate. The appointee must, within 2 working days after the appointment, apply for a manager's certificate, and if an application is made, the temporary manager must form from the time of the appointment until the application is determined to be deemed for the purposes of this act to be holder of a manager's certificate. If the appointee does not apply for a manager's certificate within that period of 2 working days, or if the application is refused, the licensee must cease to employ the appointee as a manager. Acting manager. Despite any other provision of this act, a license may appoint an acting manager for any period not exceeding 3 weeks at any one time where a manager is unable to act because of illness or absence, and for periods of not exceeding in the aggregate 6 weeks in each period of 12 months to enable a manager to have a vacation or annual leave. Every person appointed... Did I hear a quack in my... Yeah. Oh. Has the screen gone? Again. Why is it showing up like that? Yeah, the screen's gone. Why? Why is the screen gone? Come back. Okay. Just disappears sometimes. That's annoying. Come back on here now. It is back on here. Cool. It's back on there. Yes. That's not gonna... Jeez, this is weird. Stay on, please. Please stay on. Okay, I think we're good now. Yeah, every person appointed as an acting manager in accordance with this section must, while the appointment continues, be deemed for the purposes of this act to be the holder of a manager's certificate, and it is not necessary for that person to apply for or hold a manager's certificate. Okay. 231. Notice of appointment, etc., of a manager, temporary manager, or acting manager. A licensee must give notice in accordance with subsection 2 of the appointment or the cancellation or termination of the appointment of any manager, temporary manager, or acting manager. The notice is given in accordance with this subsection if the notice is given within 2 working days after the appointment or cancellation or termination of the appointment. 2. The licensing committee with which the application for the license was filed, and the constable in charge of the police station nearest to the premises where the license is in force for any premises, or the office of the licensing committee with which the application was filed where the license is in force, or a conveyance. It is not necessary to comply with subsection 1 in respect of the appointment of the temporary manager or an acting manager for any period not exceeding 48 consecutive hours. The licensing committee may, within 5 working days after receiving a notice of the appointment of any temporary manager or acting manager, notify the licensee that it does not approve the appointment, in which case it must give a copy of the notice to the constable referred to in subsection 2b. On receiving notice under subsection 4, the licensee must terminate the appointment with effect from a date not later than 5 working days after the date of the notice. 232. Licensees to keep record of managers, acting managers, and temporary managers. Every licensee required by this act to appoint a manager or managers for any premises must, in respect of each manager, acting manager, or temporary manager appointed for the premises, record in a form that is readable or retrievable, the information prescribed by regulations made under this Act for the purposes of this section. The licensee must keep the information recorded for at least 2 years after it is recorded. Subpart 8. Offences and closure of premises. Unlicensed persons and unlicensed premises. Sales by unlicensed persons. A person who does not hold a license and sells or displays or keeps for sale any alcohol commits an offence. A person who commits an offence against subsection 1 is liable on conviction to either a term of imprisonment of not more than 3 months or a fine of not more than $40,000. 2 through 4. Allowing unlicensed premises to be used for sale of alcohol. A person who is the occupier or one of the occupiers of any unlicensed premises commits an offence if that person allows any other person to sell or display or keeps for sale any alcohol in those premises. A person who commits an offence against subsection 1 is liable on conviction to either a term of imprisonment of not more than 3 months or a fine of not more than $40,000. Oh, he's a number 100. Oh, he's got 75 XP. P35. Use of unlicensed premises as a place of resort for consumption of alcohol. A person who is the occupier or takes part in the care, management, or control of any unlicensed premises commits an offence that if that person allows those premises to be kept or used as a place of resort for the consumption of alcohol. A person who commits an offence against subsection 1 is liable on conviction of a fine of not more than $20,000. Subsection 1 and 2 do not apply for the consumption of alcohol by any person on any premises on which that person resides, whether that person is the occupier of the premises or not, or supplied to any person by way of gift by any person who resides on the premises on which the alcohol is consumed. A person who acts as, or as if he or she were, an occupier or a person having any part in the care, management, or control of any premises is to be treated as an occupier of the premises, but without affecting the liability of any other person. Premises may be treated as being kept or used as a place of resort for the consumption of alcohol, even though they are open only for the use of particular people or particular classes of person, and not all people who wish to use them. 235A. Exemption to Section 235 for certain race meetings. Section 235 does not apply in the following circumstances. The person A referred to in Section 2351 is a small racing club, and the consumption of alcohol takes place on a day when A is using the unlicensed premises referred to in Section 2351 to hold a race meeting, and holds either an on-license or an on-site special license that applies to an area within the premises for the duration of the race meeting. In this section, the following terms have the same meanings as in Section 5.1 of the Racing Industry Act 2020. Race meeting and small racing club. 236. People found on unlicensed premises kept as place of resort for consumption of alcohol. A person who is not a constable acting in the execution of his or her duty commits an offence if he or she is found on any unlicensed premises kept or used in breach of Section 235. A person who commits an offence against subsection 1 is liable on conviction to a fine of not more than $2,000. It is a defence to charge under subsection 1 if the defendant satisfies the court that he or she was present on the premises for a lawful purpose and neither took part nor intended to take part in any unlawful sale, supply, or consumption of alcohol. Irresponsible promotion of alcohol. Irresponsible promotion of alcohol. A person commits an offence if, in the course of carrying on a business, that person does anything that encourages people or is likely to encourage people to consume alcohol to an excessive extent, whether on licensed premises or at any other place, or promotes or advertises discounts on alcohol in a way that leads people or is likely to lead people to believe that the price is 25% or more below the price at which the alcohol is ordinarily sold, otherwise than on licensed premises or in the catalogue or similar price list of the holder of an off license endorsed under Section 40. That 25% was, I think, a case where in a New World in the South Island had an advertising outside the venue of some alcohol for something like 26%, and they got pinged for that, I think. Okay. Or this again, or holds or has on license premises a promotion or advertisement of discounts on alcohol. Oh, this was the one. Of discounts on alcohol that leads people or is likely to lead people to believe that the price is 25% or more below the price at which the alcohol is ordinarily sold, and can be seen or, in the case of an audible promotion or advertisement, heard from outside the premises. That was the New World one in the South Island, because they had advertising outside the building. Or promotes or advertises alcohol that is free of charge, otherwise than by promoting or advertising the complimentary sampling of alcohol for consumption on premises for which an off license is held, or by a promotion or advertisement within licensed premises that cannot be seen, or in the case of an audible promotion or advertisement heard from outside the premises, or offers otherwise than by means of an offer made only on licensed premises and made only in relation to the buying of alcohol on those premises, any goods or services, or the opportunity to obtain any goods or services, or the opportunity to win a prize on the condition that alcohol is bought, or promotes or advertises alcohol in a manner aimed at, or that has, or is likely to have a special appeal to minors. The offers one was offers. Reading E again. Offers otherwise by any means. Oh yeah, it's like incentives. 2. Subsection 1E does not apply to a loyalty program that provides rewards or discounts unless the rewards or discounts apply only or primarily to alcohol. 3. A person who commits an offence against this section is liable on conviction in the case of a license to either or both of the following: a fine not more than $10,000, or the suspension of the licensee's license for a period of not more than 7 days. B, in the case of any other person, a fine of not more than $10,000. Banned and restricted alcohol products. Offences relating to banned and restricted alcohol products. Every person commits an offence who imports, manufactures, distributes, or displays for sale a banned alcohol product, or sells a banned alcohol product to any person, or otherwise than in accordance with regulations or made under this Act, imports, manufactures, distributes, displays for sale, or sells to any person a restricted alcohol product. A person who commits an offence against this subsection 1, is liable on a conviction to a fine of not more than $20,000. Offences relating to minors and people under the purchase age. Sale or supply of alcohol to people under the purchase age on or from licensed premises. A licensee or manager of any licensed premises who sells or supplies alcohol or allows alcohol to be sold or supplied on or from the licensed premises may, to any person who is under the purchase age, commits an offence. A person who is not a licensee or a manager of any licensed premises who sells or supplies the alcohol from or on or from the licensed premises to any person under the purchase age commits an offence. A person who commits an offence against subsection 1 is liable on conviction in the case of a licensee to either or both of the following: a fine not more than $10,000, and the suspension of a licensee's license for a period not more than 7 days. In the case of a manager, to a fine of not more than $10,000. A person who commits an offence against subsection 2 is liable on conviction to a fine of not more than $2,000. Subsection 2 applies despite any liability that may attach to the licensee or any manager in respect of the same offence. Subsection 2 applies. Oh yeah, licensee. So if someone that's not a manager sells to a minor, they get pinged $2,000, and also the manager might as well. In any proceedings for an offence against subsection 1 or 2, in respect of selling or supplying alcohol or allowing alcohol to be sold or supplied to a person, the customer, is a defence if the defendant proves that before or at the time of the sale or supply of alcohol concerned, there was produced to the person who sold or supplied the alcohol a document purporting to be an approved evidence of age document, and like an ID, photo ID, and the person believed on reasonable grounds that the document was an approved evidence of age document and related to the customer, and indicated that the customer was not under the purchase age, and the person reasonably believed that the customer was not under the purchase age. In any proceedings for an offence against subsection 1 or 2, in respect of selling or supplying alcohol, or allowing alcohol to be sold or supplied to a person, a customer, is a defense. Is a defense if the defendant proves that before or at the time of sale or supply of alcohol concerned, the person who sold or supplied the alcohol verified the customer's age using an approved evidence of age system in the approved manner. A person does not commit an offence against subsection 1 or 2 by selling or supplying alcohol to a person who then supplies it to a third person who is under the purchase age, unless it is proved that the person knew or had reasonable grounds to believe that the alcohol was intended for a person under the purchase age. So that is checking, like, you have to go completely, if the person you're supplying the alcohol to looks, not is, but looks under the age of 25, you ask for ID. Check it. Check both sides and feel it, because sometimes they might have a sticker saying 2004 and their actual birthday is actually 2008. You actually got to check, because they might cover that up and pretend to be older than they actually are. And then you've got to check the expiry date, because it's got to be valid to be a approved evidence of age document. And the section 8 is like a selling or supplying alcohol to person. Like, it's also okay, like, you give alcohol to a parent or legal guardian of someone, and they can, because the person who's under the age is legally not allowed to purchase it for themselves. So, but a parent can buy the alcohol, and then after that, then we give them, let's say, a beer. Then they give their child, yeah. But that's a bit iffy, because it's also, and it does improve the person on you. We can't really have any grounds to believe that it was intended to go that way. Because sometimes people, it also counts for people getting cut off that way. Like, you give someone you sell someone a beer, and then they give it to someone also that you've literally just cut off, saying, oh, no more, have some water. And then they will go and have some water, but then someone else will come to the bar, buy a beer. You think it's for them, send that away, they have their beer, but then they sneak it to the person that just got cut off, and then they continue drinking, which is on grounds, and they're like, yeah, we have to remove you. Then we cut both of them off, and then we kick them out. But that's some interesting stuff. 240. Exemptions in respect of licensed premises. Section 239, 1 and 2 do not apply to the supply of alcohol on licensed premises other than a restricted area to a person under the purchase age. If the person is, this is the parent or guardian one. A person is accompanied by his or her parent or guardian, and the alcohol is supplied by his or her parent or guardian. So yeah, this one is like, you're selling it to someone over 18, and then without our knowledge, they supply it. But if we find out, we've got to cut them off. But if we don't find out, well, we can't do much about it. But this one is parent and a under the purchase age 18. Oh, no, let's say someone's 17, and then they're with their parent who's 40 something. They can buy their kid a drink, but they have to buy it. And I think in this, it's supplied by the parent or guardian. So the kid can ask their parent for a drink, and then the parent asks the bartender. Then the bartender supplies the drink to the parent, where the parent supplies the drink to the kid. We cannot directly supply a drink to a kid. It has to go through the parent first, parent or legal guardian. That's that 240. And also that it has to be in a venue where they allow people under the age of 18, so like a family venue or something. If it's a restricted venue where they have a limit on the minimum age, I think that doesn't apply, because you wouldn't be allowed in if you were under 18 anyway. 241. Supplying alcohol to minors. A person who supplies alcohol to a minor commits an offence. A person who commits an offence against subsection 1 is liable on conviction to a fine of not more than $2,000. It is a defence to charge under subsection 1 if the person supplying alcohol, the supplier, is a parent or guardian of the minor and supplies the alcohol in a responsible manner. So if the kid's drunk, you got to stop serving them. But if the kid's like having only 1 or 2 beers, then that's okay. That's a responsible manner, and they're not excessively drinking, like taking shot after shot after shot if they're having shots or something like that, or drinking really fast. That's a defense. Or believes on reasonable grounds that the minor is not a minor, ID, believes on reasonable grounds that let's say they look over 25, believes on reasonable grounds that with ID, sorry, that's still B, believes on reasonable grounds that subsection 7 down there, I'll go back to that, applies to the minor and supplies the alcohol in a reasonable manner, or where's up to, or believes on reasonable grounds that he or she has the express consent of the parent or guardian of the minor and supplies the alcohol in a responsible manner. That's the same thing with the parent or guardian I explained earlier. When considering for the purposes of subsection 3, A, C, or D, whether alcohol was supplied to any person when considering the purposes of subsection 3, A, C, or D, not B, whether alcohol was supplied to any person in a responsible manner, the court may, in relation to the occasion on which the alcohol was supplied, take into account the following: the steps taken by the supplier to supervise the consumption of alcohol, whether food was provided with the alcohol. So yeah, if it's a minor, you'd want to give them food as well. Whether a choice of low alcohol or non-alcoholic beverages or both was offered, we have those. The nature of the occasion, any arrangements for or provision of safe transport, taxis, buses, not driving. the period over which the alcohol was supplied, the strength and volume of the alcohol supplied, the age of the minor, and any other matter. So like the age of the minor, let's say if they're 10, you probably don't want to supply them anything. If they're like 16 or 17 and it's through the parent, then that's more okay. Then any other matter it thinks relevant in the particular circumstances. Subsection 1 applies irrespective of any liability that may attach to the license or any manager or other person in the respect or of the sale or supply of the alcohol. A person does not commit an offence under subsection 1 by supplying alcohol to a person who then supplies it to a third person who is a minor, unless it is proved that the person knew or had reasonable grounds to believe that the alcohol was intended for a minor. Yeah, that's that. Another one coming up again. So supply it to people who are not minor. That's the one. The third person one is tough because it's hard to actually figure out who the alcohol is going to. So usually, if it's a large group that come in, you check if there's just one person that looks under the age of 25, then you check everyone's IDs instead of just that one person, usually. That's what I do. This subsection applies to the minor at any time if he or she is then no longer subject to guardianship by operation of Section 28 of the Care of Children Act 2004. I think that means, like, because it's a supervised venue, the parent or legal guardian has to be around to the minor and must be able to control the minor as well. And if that person is unsupervised, then they can't have any alcohol. But they have to be supervised, and obviously the parent can't be intoxicated either. They have to be in a manner to be able to supervise. 242. Employment of minors. A licensee of any licensed premises who employs a minor in any capacity is in any restricted area on the premises while that area is open for the sale of alcohol commits an offence. I know. Oh, the kitchen. The kitchen. Does the kitchen apply to that? Because technically there's a walkway between the kitchen and the bar, but I'm not in control of the kitchen. It's not my problem, but the people in the kitchen, the head chef, does that count for them if they have a minor in the kitchen working, like a KP who's under the age of 18 with no parent there? A person who commits an offence against subsection 1 is liable on conviction to a fine of not more than $2,000. Subsection 1 does not apply to the employment in a restricted area of any person for the purpose. Oh, here we go. Subsection 1 does not apply to the employment in a restricted area of any person for the purposes of preparing or serving a meal, cleaning, repairing, maintaining, altering, or restocking the area or any equipment in the area, or removing or replacing any equipment, or stock taking or checking or removing cash. So yeah, if someone's under 18 in the kitchen being a KP or doing dishy or doing a bit of prep for the kitchen, that in this seems to be okay. Got it. So the kitchen is actually fine. 243. buying of alcohol by people under the purchase age. A person under the purchase age who buys alcohol on or from any licensed premises commits an offence and is liable on conviction to a fine of not more than $2,000. Subsection 1 does not apply to a person who buys alcohol on or from any licensed premises at the request of a constable acting in the course of his or her duties. So a constable can go up to a minor and ask them to buy alcohol? Okay. Minors in restricted areas or supervised areas. A minor who is found in a restricted area on any licensed premises commits an offence. A minor who is found in a supervised area on any licensed premises commits an offence unless he or she is accompanied by a parent or guardian and must be supervised at all times. Like, we have sections of our bar where there's a restricted area, then there's a supervised area, but the supervised area is until 10 p.m, I think, before it goes restricted, or it's unsupervised and then becomes supervised at 10 p.m. I'll have to check that. But yeah, supervised at all times, pretty much. A person who commits offence against subsection 1 or 2 is liable on conviction to a fine of not more than $1,000. Subsections 1 and 2 do not apply to a person who is an employee or agent of the license, or a person acting under a contract with the licensee or manager, and who is in the restricted area or supervised area for the purposes of cleaning, repairing, maintaining, altering, or restocking the area or any equipment in the area, or removing or replacing any equipment, or stock taking or checking or removing cash, or who is in the restricted area or supervised area for the purpose of preparing or serving a meal, kitchen, or who is in the restricted area or supervised area at the request of a constable during the acting in the course of his or her duties, or who is in the supervised area or purpose of selling or supplying alcohol. Yeah, there it. 245. Permitting minors to be in restricted areas or supervised areas. A licensee or manager of any licensed premises who allows a minor to enter or remain in a licensee or manager of any licensed premises who allows a minor to enter or remain in a restricted area or supervised area in contravention of Section 244 commits an offence. A person who commits an offence in subsection 1 is liable on conviction to a fine of not more than $2,000. In any proceedings for an offence against subsection 1 in respect of allowing a person, the customer, to enter or remain in a restricted area or supervised area is a defence if the defendant proves that there was produced to the defendant or an agent or employee of the defendant a document purporting to be an approved evidence of age document, and the defendant, agent, or employee believed on reasonable grounds that the document was an approved evidence of age document and related to the customer and indicated that the customer was not a minor, and defendant, agent, or employee reasonably believed that the customer was not a minor, and the defendant satisfies the court as soon as the defendant, agent, or employee became aware of the situation. Reasonable steps were taken to remove the customer from the restricted area or supervised area. In any proceedings for an offence against subsection 1 in respect of allowing a person, the customer, to enter or remain in a restricted area or supervised area. It is a defense if the defendant proves that the defendant or an hello again. Oh, I knew what was happening. You can't get me the door knock again. I was ready for it. I'll read it. Hang on. All right. To enter or remain in the restricted area, it is a defense if the defendant proves that the defendant or an agent of or employee of the defendant verified the customer's age using an approved evidence of age document system in the approved manner. 246. I'm going to keep going until 2 hours. I've got 10 minutes left, I reckon. It's 150 now. 246. It's like 400 sections long. So I'm just over halfway. Yeah. Who is guardian? For the purposes of this act, a person is a minor's guardian only if he or she is a guardian by virtue of the Care of Children Act 2004. Other offences on licensed premises. Unauthorized sale or supply. A person who is a licensee or a manager of any licensed premises must take all reasonably practicable steps to ensure that the licensee does not do any of the following things without the authority of this act: sell or supply alcohol on the premises for consumption there, or let people consume alcohol on the premises, or sell or supply alcohol on the premises for consumption somewhere else. A person who commits an offence against subsection 1 is liable on conviction in the case of a licensee or to either or both of the following: a fine not more than $20,000, the suspension of the licensee's license for a period of not more than 7 days. In the case of a manager, a fine of not more than $20,000. 248. I've got 8 minutes. 8 minutes to go on this. Ooh. Mm-hmm. Sale or supply of alcohol to intoxicated people. The licensee or a manager of any licensed premises who sells or supplies alcohol to an intoxicated person commits an offence. A person who commits an offence against subsection 1 is liable on conviction. In the case of a licensee to either or both of the following: a fine of not more than $10,000 and the suspension of a licensee's license for a period of not more than 7 days. In the case of a manager, a fine of not more than $10,000. A person who is not a licensee or manager of licensed premises and who sells or supplies alcohol to an intoxicated person commits an offence. A person who commits an offence against subsection 3, that one just there, is liable on conviction of a fine of not more than $2,000. Subsection 3 applies irrespective of any liability that may attach to the licensee or any manager in respect of the same offence. 249. Allowing people to become intoxicated. The licensee or a manager of any licensed premises who allows any person to become intoxicated on the premises commits an offence. And if a person commits an offence against subsection 1 is liable on conviction in the case of a license to either or both of the following: a fine of not more than $10,000 and the suspension of the licensee's license for a period of not more than 7 days. And in in the case of a manager, a fine of not more than $10,000. 250. Manager intoxicated on duty. A manager of licensed premises who is intoxicated while on duty on the premises commits an offence. A person who commits an offence against subsection 1 is liable on conviction of a fine of not more than $4,000. A manager cannot be intoxicated while they're on duty. Employee intoxicated on duty. An employee of the license of any licensed premises who is intoxicated while on duty of the premises commits an offence. A person who commits an offence against that is liable on conviction of a fine of not more than $2,000 for an employee. 252. Allowing intoxication on licensed premises. The license or a manager of any licensed premises who allows licensee or manager of any licensed premises who allows an intoxicated person to be or remain on the licensed premises commits an offence. So that you have to get them to leave, ask them to leave. A person who commits an offence against subsection 1 is liable on conviction to a fine of not more than $5,000. It is a defence to a charge under subsection 1 if the defendant satisfies the court as soon as the defendant or any employee of the licensee became aware of the situation, reasonable steps were taken in respect of the intoxicated person concerned, either to take the person to a place of safety on the licensed premises or to remove the person from the licensed premises. Allowing disorderly conduct on licensed premises. The licensee or manager of any license the licensee or a manager of any licensed premises who allows any violent, quarrelsome, or insulting or disorderly conduct to take place on the licensed premises commits an offence. A person who commits an offence against subsection 1 is liable on conviction to a fine of not more than $10,000. It is a defence to a charge under subsection 1 if the defendant satisfies the court that as soon as the defendant or any employee of the license became aware of the situation, reasonable steps were taken in respect of each person involved in the conduct. Each person involved in the conduct concerned, either to take the person to a place of safety on the licensed premises or to remove the person from the licensed premises. Sale of spirits in vessels exceeding 500 mils. You cannot do that. Spirit. So like a vodka lemonade, 30 mils of vodka, but then in a big glass, you can't do that. The licensee or manager of any licensed premises or the licensee or manager of any licensed premises or an employee of the licensee who sells or supplies any spirit to any person for the consumption on the licensed premises in a vessel exceeding 500 mils commits an offence, even if it's like one shot, 30 mils of vodka, and the rest of it is mixer, which is non-alcoholic. And if it goes over 500 mils, that's an offence. Where if it's like a smaller glass, I think the size would be like a rocks glass or something, would be 300 at most mils, and that's fine. But it has to be, of course, you're not giving them entirely vodka. A person who commits an offence against subsection 1 is liable on conviction to a fine of not more than $2,000. Subsection 1 does not apply to the sale or supply of any spirit to a person who is a lodger on the licensed premises for consumption in the part of the licensed premises in which that person lodges. 255, and that's a big one, so I'm going to leave it there. Hang on, let's see how far we're through. Where's 255? That's the one there. It's now been 2 hours. Yeah. Oh my god. 2 hours of reading again. Now I've got 150 odd sections to read after this. Yeah. I'm going to close the stream now. So I'll say goodbye.